Good. I'd like to call to order the Tuesday, March 5th, 2013 meeting of the Township of South Orange Village Board of Adjustment. May we have a roll call?
Yes, Mr. Don.
Here.
Mr. Descalo.
Here.
Mr. Groman. Mr. Parlapiano.
Here.
Mr. Reeves.
Here.
Mr. Semper.
Here.
Mr. Adler. Mr. Shapiro. And Ms. Waring.
We're expecting Mr. Shapiro to join us shortly. Pursuant to Section 5, Chapter 231, PL 1975, this is to state for the record that adequate notice of this meeting has been provided to the public by posting and maintaining the annual notice of regular meetings on the bulletin board in Village Hall, by publishing the annual notice of regular meetings for 2013 in the December 2012 edition of the South Orange Maplewood News Record, and by filing said notice in the office of the village clerk. So we'll move on. The first order of business is approval of minutes from our Tuesday, February 5th meeting. We received those minutes, and people, Mr. Adler, you had some things, and I have actually the track changes here. Thank you, Jetta, for doing that. Makes it easy to look at. Does anybody have comments about the tracked changes?
No.
Good.
They look good.
Mr. Descala, you added some changes there too. That was good. All right, so if nobody has any questions or problems with it,
I move the minutes, we accept the minutes as changed.
Second.
Okay, Mr. Don.
yes.
Mr. Descalo.
Yes.
Mr. Parlapiano.
Yes.
Mr. Reeves.
Yes.
Mr. Semper.
Yes.
Mr. Adler.
Yes.
Okay, so we were going to have a very crowded agenda tonight, but it's not going to be so crowded. I wanted to move to dispose of for this evening any questions on case 999, which is Garden State Property Management. Is anybody here from Garden State Property Management? Okay, we received an email from Garden State Property Management that they wanted to adjourn to April. Mr. Rinda?
Yes, that's correct. They've asked to move till April. They encountered an issue with their notice in the newspaper. They had already sent out their individual notices to the property owners within 200 feet, but the newspaper failed to get it into the paper on time. So they've asked to carry it to the next meeting so that they can properly advertise in the newspaper, and ask that the board at tonight's meeting let anybody know from the public that it's being carried to that meeting so they wouldn't have to renotice again. Patrick, I believe you spoke with them.
He did. He called me, Mr. Chairman. I also received a letter from him requesting that it be carried to the next month's meeting.
So that's what we'll do. We'll carry it to next month's meeting, and we'll put them first on the agenda for next month, Jetta.
Do we have other cases for next month, other than that?
Well, there's a couple of other applications that are here for completeness, but that one would have been ahead of those other applications anyway.
Okay. All right, so that will leave us with three main things to do, but again, before we get to the actual cases, wanted to see, is it appropriate to do the resolutions at this point, or should we wait till the end of the meeting? Does it matter?
The
Resolutions
appointments?
for appointments for...
Do it now.
Okay, let's go ahead and do that now. So we have three appointments to make, and I'd like to, if the board sees fit, to somebody to make a motion to adopt a resolution. So for the first would be for the board attorney, for Mr. Dwyer to continue as our board attorney. We didn't actually do a resolution, and that's the proper thing to do, to have him continue, since there was an RFP put out. Does anybody have any comments about Mr. Dwyer? I'll give some comments. He's done a great job for several years. You've represented us well. You've been very reliable in the meetings, and also all the stuff that goes on outside the meetings that nobody ever hears about, that requires dedication and persistence, and even in representation before the court on several occasions. You've done a great job. I
want to raise.
Never has a more solid attorney sat at this board or represented this board.
So can we have a motion?
I'll move to continue Mr. Dwyer as the attorney representing board.
We have a
Second?
What? Yes. And let the record reflect that Mr. Shapiro has arrived.
Okay. Mr. Don,
Yes.
Mr. DeScalo,
Yes.
Mr. Parlapiano,
Yes.
Mr. Reeves.
Yes.
Mr. Semper,
Yes.
Mr. Adler,
Yes.
and Mr. Shapiro.
Yes. And
Thank you.
you're welcome. And then next is for our planner. We put out an RFP, or actually the Board of Trustees put out an RFP for a planner. I would propose, I would propose that we continue with Hire Gruel as our planner. They've been our planner for a couple of years. They've done a great job. Ms. Gruel is here tonight. They've been reliable. They've shown true expertise. They've been very helpful in addressing our particular concerns. It's not kind of a cookie cutter approach. They're not too big to ignore us, and on the other hand, I don't feel like it's too small that they can't answer the questions. They also, the history with South Orange in particular, I think has been helpful in creating the master plan, and that sort of expertise shows through in how they approach this board, because they know the town. Do we have any other comments or questions?
Well, I was, as was Mr. on the committee that reviewed all the applications. There were several. Most of them were very large, as you said. Didn't have the level of experience that's been exhibited at our meetings with this kind of community. A lot of times, a lot of the firms that we looked at, they had more junior people that would be assigned to this town. It's something that we didn't feel would be appropriate. I feel like we've been given the respect that we deserve by Hire Gruel, and I'm happy to give it back.
Mr. Don, you have any?
I think that Hire Gruel is a very good firm for us, for what we need, for the responsiveness that we've gotten from them, and I think for the sort of personal touch and the knowledge of the town. So I as Mr. DeScalo said, I wholeheartedly endorse them to be our planners and engineers for the year.
We have any other comments, questions? If not, may we have a motion?
I move that we retain Hire Gruel as our engineering firm. Planning firm.
I'll second that.
Okay, Mr. Don,
Yes.
Mr. DeScalo.
Yes.
Mr. Parlapiano,
Yes.
Mr. Reeves.
Yes.
Mr. Semper,
Yes.
Mr. Adler,
Yes.
and Mr. Shapiro.
Yes.
Thank you very much. We appreciate it.
Good to have you continue to work with us.
Thank you for your confidence.
The third appointment is appointment of an engineering consultant. And there was also an RFP put out for an engineer. And along with me, Mr. DeScalo and Mr. Don were part of the committee to look at the engineers that submitted applications. In this, I don't think we've ever, at least since my tenure, I don't think we've employed an engineering firm to help us.
Outside.
An outside engineering firm to help us. It's, Sal, you've taken care of things, the planners taken care of things.
It doesn't happen very often, but occasionally there's the potential for an application, which requires more extensive engineering review and comment and recommendation than we can provide in-house. So the recommendation would be to have an engineering consultant on board, and it would be used at the board's
Right.
discretion.
But in order, also for efficiency, the planning board does use engineering testimony more often. And
Yes.
they've chosen Omland.
Correct.
Okay. And I was, personally, I was fine with any one of a number of engineering firms. It's not my area of expertise. There were many good applications. They chose Omland. I personally am willing to go along with what the planning board goes for simply for efficiencies and cost sake. Given the fact that we've never used a private engineering firm, I can't claim that one is better than the other.
Just so you understand the planning board, and my recommendation to the planning board, Omlin was the one firm that could provide also transportation engineering expertise within their firm. Most of the other firms have a lot of experience with planning boards and zoning boards and land development and things like that, but Omlin was the one firm that had that one component of transportation engineering as well, which is a very important component, for some of the applications that may pop up in the future.
How do you spell Omland?
OM, land.
OMLAND.
Do we have any other comments about the engineering consultant, questions?
I can just say that in my life outside of South Orange, I've worked with them on projects, both as them being town engineers and them being applicants' engineers, and I've found them to do good work. They have good staff, and the added plus is that they can do traffic at the same time. So I think for those occasions when we may need it, they're a good firm to have for us to refer to.
All right, so may we have a motion?
I move that we accept Omland Associates as our engineering firm, should we need one.
I'll second. Keep the trend going.
This is the left side trend there.
Okay, Mr. Don?
Yes.
Mr. DeScalo?
Yes.
Mr. Parlapiano?
Yes.
Mr. Reeves?
Yes.
Mr. Semper?
Yes.
Mr. Aller?
Abstain.
And Mr. Shapiro?
Yes.
Okay, so now we get to the three cases this evening. The order that we're going to take these is the two completeness hearings first. The first one will be Molinaro, 174 Church Street. Second will be 124 Fifth Street, Bianca LLC. And then the third application will be Bikrov Group Gas for the interpretation of the denial from the zoning officer.
They haven't sounded out yet, but you may.
So, well, Mr. Molinaro or your representative, are you all here? 174 Church Street?
170, the attorney for 174 Church asked if it was going to be on for completeness, and I told him it was, and he asked if he needed to be here, and I told him if there was any questions that came up, you should be here, but, he wasn't sure that he was going to be here, and I'm not sure. I didn't speak to anybody from Mr. Molinaro. So, no, they're residents, I believe.
Well, we can do the completeness without
Yeah,
them here.
they don't need to be here for the completeness, but
All right, so let's move.
anything the board decides, we'll just pass the information on to the applicants.
Okay, so remember, this is a completeness hearing. Try to be expeditious about this. This is 174 Church Street. And they are this is currently a single-family home with a detached garage in the rear yard, surrounded by other single-family, multifamily residential dwellings. It says R22 district of the Church Street redevelopment area. And the applicant is proposing to construct a two-story addition to the existing structure and to convert the family from single-family use to two-family use. So Higher Gruel did a completeness review here, and they noted that they've not completed all the required submissions, but they recommend that the application be deemed conditionally complete, provided that the required items be submitted at least 2 weeks prior to the public hearing. So what we've normally done is we've asked Ms. Gruel to take us through these various items. You don't need to read them. I'll march through them, and if you have anything to say, Ms. Gruel, yeah, okay? And likewise, if we have any questions.
I think the key, if I may this is a little different than your normal application, because originally they had submitted an application for a D variance, for a use variance. When in our review for completeness, we noted that we believed that it was not for a D variance, they needed C variances, but that they did not need a D variance. Our office did call the attorney, did speak with him. He said, okay, basically. And so he is aware of our opinion. He did not dispute that opinion, and I just wanted to note that, which is a little different than what you normally have for completeness, because of what the application is for.
So what you're saying is that a two-family in this zone is a permitted use?
Is a permitted use, correct.
Okay,
So I just wanted to raise that up
thank you.
front.
So, and that gets to the very end of your report, so then that the only variances required are bulk variances for minimum lot width and minimum lot area requirements. Okay, so with that understanding, why don't we go ahead and start going through the application checklist. There was item 1. Waiver for completeness on the checklist. Any problems with that? Item 5. Did they submit that? The list of property owners within 200 feet?
Yeah, it's
Didn't
in
we
this
just look at
package,
it?
but,
I think we got it subsequent
I
to,
think we did.
subsequent to.
Thought we did.
No, it's a
Maybe-
different application.
Yeah,
Yeah, not in this file.
Okay, so
That was the other completeness one that we
now
got.
they need that in order to notify.
Right.
Yes. And
Yes,
that's
they
why-
will have to get the list of property owners within 200 feet.
Excuse me?
I believe they've already received it. Did they submit? I think they came in the other day.
We got a property list from the other applicant, I think it was the
Correct.
gas station.
Yes.
No, we got it from Bianca.
From Bianca,
Yes.
okay, right. So,
But they would have to file it as part of their
Right.
notice anyway.
Don't really need it right now.
right, we don't really need it now, okay,
So they will have to do that because they will
Right.
have to notice.
okay. Item 9, not submitted a public hearing notification, well, that will be done. And I'm just gonna keep moving, if you guys have anything, let me know. The applicant is not provide, item number 10, for utility purposes.
There was already a house on the site, I would assume that it already had utilities.
Right.
The applicant has not submitted an application from the county planning board, but it's not on the county road, so they wouldn't need to in any case. Is that correct?
Right.
Correct.
Okay. Item number 12, no application to the Essex County Health Department.
That's fine.
And again, these permits or approvals as required are typically made as conditions of approval. I don't have any problem with that. Any problems there? Item 13, soil disturbance application. These are typically made as conditions of approval.
Right.
Okay. Item 14, not submitted copies of DOT or DEP approvals. And again, typically made as conditions of approval. Item 18, not submitted photographs.
I think we should get those.
Yeah.
He's gonna,
Well, we can ask
Yeah,
Yes,
2
right.
weeks prior,
Right.
right?
Okay, so again, for
For
completeness,
completeness, it's fine, but that should be
yes,
something that
they should submit those. Can we communicate that to them? Mr.
Actually,
Dwight?
it's in this school's,
Yeah.
I don't know. She's already indicated it.
Okay, so they know this.
They
Yeah.
received a copy of
Okay.
this, so I hope they read it.
Okay, okay, good. All right, 19, traffic and parking impact.
Correct.
Yeah, I don't think they're going to need one of those.
Right.
The applicant, 35, critical environmental areas. The applicant will need to address any impact the development of the site may have on the river through testimony. Okay. Item 36, not identified any existing trees, but they should provide a list of all trees having a caliper 4 inches or greater, at least 2 weeks prior to a public hearing. Are we okay with that?
Yes. As long as they submit it.
Existing well, 37, existing wells or septic systems. They need to provide this 2 weeks prior to a public hearing. Not submitted a landscaping plan. And the applicant should note that we may request this for the hearing.
That's something we would do now, or?
Well, I think we should request that they submit a landscaping plan, given the fact that they're basically redeveloping the site and covering a good amount of the site with paving.
Okay. Do y'all agree?
Yeah.
Okay, so how do we get word to them that they should submit a landscaping plan?
I notify them, Mr. Chairman.
Thank you. Item 44, all existing structures within 200 feet. And again, they should provide this information before the hearing. Planning comments? Okay. No. All right, any comments on this?
Yeah, I have one other comment. The drawings don't address it, but it would be good to have some idea about the topography of the site. Now, how it slopes.
Given the river,
Yeah, and given the quantity of impervious paving, I'd like to know where all that water's going. Not onto the guy next door.
right. Right.
Isn't a survey required for an application?
Yeah, I think there's something on the checklist about topography, 2-foot increments.
Contour lines, 2-foot increments?
Is that required?
That's where I'm going. I don't believe so, but it certainly is relevant when it comes to the issue of runoff. I'm looking at the checklist
Yeah,
just to, it would, because this is a variance application only, it's the checklist for variances.
It's not necessarily a site plan
Right,
application,
that's
because it is
what-
a two-family house, and that's why
Yeah.
it's before. Also, the property does not immediately butt up against the river. There's another
right.
property behind it. If the board is concerned about a topographic survey, you could request it, but it's not necessarily a
It
checklist
says
requirement.
In this district, 70% lot coverage is allowed. They've got 50% now, they're proposing to go to 60%, so they're still under the lot
Yeah,
coverage.
there's no variance for the lot coverage.
No.
We still want a topographic study?
Well, I would like to at least have some indication of where the site's draining. Because they're not proposing any on-site detention, and it's not required, but I'd like to know that it's not all spilling directly to the property owner to the north. I mean, I think it would be, and I'm not asking for a detailed topographic survey, if they could even give us a couple of points so we just get a feel for how this site is draining.
Okay, so how can you word that for Mr. Dwyer so he can communicate that to the applicant?
Spot elevations?
Right.
Violations.
Spot elevations.
Maybe at the 2 at the front, 2 in the middle of the site, and 2 at the back of the site. That would give us a general idea about which way it slopes.
Okay.
And that way they're not doing a whole survey of the property.
Sal, are there any special requirements because of the river?
I'm sorry?
Any special requirements because they're on the river?
No, they're not on the edge of the river, and they're not in the floodplain area. There's another property behind them, between them and the...
Before you get to the...
Right, between them and the river easement, that, you know, basically where the river runs through. So there is another property back there, and I don't recall if it's...
So, Sal, will you give a
So the
permit?
Soil Conservation District application may address the concerns that you've raised legitimately, but they have to go through that process.
Yeah,
Right.
they would have to get a soil conservation
A soil
permit.
conservation
Most
permit.
likely, they'll have to just put silt fence basically around the back of the property. It's flowing in that direction now.
Right.
There potentially will be some additional runoff from the development by increasing the lot coverage, but they're only increasing lot coverage by,
From 50 to 60%.
by 10% of the lot area, and it's not a very large lot, so it's not a big area.
Okay, so we got the spot elevations. Do we need to do anything else?
Landscaping plan.
Landscaping
That's
plan?
right, and then,
Question. Can we find out the subdivision of C? There's, it's a C variance?
Yes.
Oh.
So I don't
They'll
know.
argue it they'll argue one or the other when they come. They'll tell us.
Will they tell us?
They
have
should.
to.
Okay. And also, the fact that it's in a redevelopment area doesn't change anything we're doing, does it?
No,
Okay.
no. It provides the zoning.
Other comments, questions, concerns? Ms. Grohl?
No?
Okay, so we've got those issues to communicate to the applicant. Given that, we have a motion to deem this complete.
Conditionally?
Excuse me?
Conditionally complete? or
Conditionally complete, yes.
Yeah, I move that we conditionally determine this application to be complete based on the items raised in the checklist, which require specific attention. Do I need to name them?
No, they're
With
here
the-
on the memo.
With the addition of a landscape plan and spot elevations, 2 in the front, 2 in the middle of the site, and 2 in the back of the site to give us a general idea about the slope of the site.
Have a second?
I will break with tradition and second that.
I was gonna be quiet no matter what.
Okay, Mr. Don?
Yes.
Mrs. DeScalo?
Yes.
Mr. Parlapano?
Yes.
Mr. Reeves?
Yes.
Mrs. Semper?
Yes.
Mr. Adler?
Yes.
And Mr. Shapiro?
Yes.
Okay, now we move on to completeness for Bianca's LLC, 124 Fifth Street. Applicant seeking to construct a new single-family house. Again, this is a completeness hearing. Do we have anybody from Bianca's LLC here? No? Okay. So, let's move along with this.
They actually made a response to Higher Rules February 18th memo.
Right, so that's, they've got a list of property owners that I think we just got a day or so ago.
Yep.
And a letter dated the 27th from their response to Higher and Grow, which is nice to see. Now, I'm looking for
I'm in the building.
rules. So this property is located on 124 Fifth Street between Prospect and Academy in the RA 50 zoning district. The lot, 5,000 square foot lot, 50 by 100 feet, is currently vacant and is surrounded by single-family homes on similarly sized lots. They're proposing to construct a 4-bedroom, 2.5-story single-family house with an attached garage on the lot. And I'll read from Higher Rules letter, their review. The applicant has not completed all the required submissions. However, we recommend that the application be deemed conditionally complete, provided that the applicant submit the remaining items at least 2 weeks prior to scheduled public hearing. Ms. Gruhl, do you have anything to add to that at this point?
No, I believe that we received many of the, if not all, the documentation subsequent to, as you noted, subsequent to the memo that they received.
Okay. Okay, so let's move through this then. Item 5, the list of property owners, well, we do have that
They gave
now.
us that.
So that's done. Item 10, letters from utility companies, and they'll request exemption pending Board of Adjustment decision.
mean, I don't know that they would need to get that unless they got an approval, so.
Right.
We can make it a condition of the
Right.
approval.
Item 11, application form to the county planning board. It's not a county road, so it's not relevant. Item 12, the applicant has not submitted to the Essex County Health Department an application. And again, approvals like this are given pending condition of our approval. Item 13,
They submitted.
they actually contacted the agency, and they said that they don't have to submit for 5,000 square feet or under. Okay. They said they will comply if it is required. Item 14, the applicant has not submitted any copies of DOT or DEP approvals. And again, this would be made a condition of approval. Item 35, the applicant has not identified existing critical environmental areas. They say their response was that to their knowledge, there's no critical environmental area in this 50 by 100 foot vacant lot. And so that's their statement.
Does that mean anything?
What?
I mean, if they say to their knowledge there's nothing there, is that, can we go off of that, or somebody with a little more credibility need to say that?
Well, that's one of these gray areas that if we wanted to investigate it, we could ask our planner or get an engineer.
By critical areas, you're typically talking about a wetland area or perhaps a steep slope area.
Or floodplain.
I'm sorry?
Or
Floodplain.
Or
floodplain.
floodplain. They're definitely not in the floodplain, they're definitely not in a steep slope, and unless the property is improperly graded, I don't believe there's any wetlands on this site. It's basically a vacant lot nestled within and surrounded by other residential lots.
Yeah, judging from the immediate neighborhood when you drive around, I don't know that there's anything specifically critical about this site.
Yeah.
Okay. Mr. DeScala, anything else on that?
No, in general, I think that it's not a bad thing to require that everybody provide a copy of the section of the floodplain map. It's available, it's cheap, it's, no big deal for them to include it. And that way we don't have to, make any assumptions. In this case, I mean, your testimony that it's not in the floodplain is good enough for me, but
We have the maps in our office.
I'm sorry?
We have the maps in our office.
So you've checked that, I see.
It's definitely not in the floodplain.
If that's our standard method, that's fine.
Item 36 does not identify the species of existing trees. Now, what do they have to say? The location and size of trees has been provided. The vast majority of trees will be removed if the site is developed. Species will be noted for the meeting. Okay? Any problem with that? Item 37. Has not submitted information for existing wells. The applicant should provide this information at least 2 weeks prior to a public hearing, and at least in their response so far, they're not aware of any wells, tanks, septic systems, and they've magnetically swept. They are noting an existing 4-inch sanitation sewer lateral at the center of the site, so we might want to ask about that.
I guess there was a house on this site at some point.
Yeah. Okay, so in summary, Higher Gruel said that they need to submit the property owners, which they've done, and identify any critical environmental areas, and they can give testimony to that effect at the hearing. Do we have any other questions for completeness for this application?
Do we want a landscape plan? There isn't one included.
Right, it is.
We do have the topography on this one.
Right.
It's
the
a soil
plans.
erosion sediment control plan,
Right.
which is nice.
I mean, the only thing I would think that we'd want to see is something on landscaping.
I agree.
It will be a single-family residence, so I don't unless you put a condition on an approval, the landscaping, they can pretty much change it however they want.
Okay.
So, I mean, if you want them to provide a landscaping plan, but does it make sense for the applicant to go through the expense of drawing up a landscaping plan that
Good point.
could change the day after? It's,
Yeah, I mean, is that what we're ruling on is not the landscaping? Yes, you'd like to see it be tasteful, but I'm not so sure I would require it in this particular case.
I take it back.
Well,
The site looks, looks like they're gonna pretty much clear the site, right? There's a lot of small scrubby trees on it, so, I mean, you're right, I mean, at some level, if they just plant grass and have a nice house on it, it's not, it's better than it is, right?
Ms. Gruhl?
Technically speaking, a landscape plan for a 1 or 2 family house is not a checklist item. It's only for a site plan application. Now, I would distinguish the other application because it's in a redevelopment area, a little bit different.
Right.
You can make that distinction. This one is in a redevelopment area. I don't think it's out of discussion with them, but I'm not sure, and this may be something that Pat could weigh in on, but I'm not sure that for completeness, it's an item. That's all.
So what if we just notify the applicant that we'd like to hear about
Prepared.
landscaping plans, right?
Yeah, I wouldn't make it, I wouldn't
That'll
say
be a
that they weren't
topic of
complete
discussion.
because they didn't
That's
submit it.
Okay.
I think it would just,
Just let them know we're gonna ask
Let
about
them
it.
know we'll ask questions about landscaping, and they might want to address that. Although for purposes of completeness, it's not relevant.
On the positive side, they're leaving 5 trees.
We have other questions or concerns about this application for completeness? Okay, so may we have a motion?
I'll move that we accept application 1001 as complete, subject to the specific questions in the planner's memo.
I'd like to second that.
Okay, Mr. Don?
yes,
Mr. DeScalo?
Yes.
Mr. Parlapiano?
Yes?
Mr. Reeves?
Yes.
Mr. Semper?
Yes.
Mr. Aller? And Mr. Shapiro?
Yes.
Okay, we're making good progress, so now we move on to the application, case 998, Edward Vickro of Group Gas, 252 Irvington Avenue. The applicant is seeking an appeal to the decision of the administrative officer. Hi, good evening.
Good evening, Mr. Chairman. My name is Stephen L. Ritz. My offices are on Milburn Avenue in Milburn. I represent the applicant. This is an appeal from a denial of a use permit application that was filed. The application was received on December 5th, 2012, and the zoning officer denied that application on December 7th, 2012. I think for the record, you can confirm that we filed an affidavit of publication and an affidavit of service. I would hope that the council has found that to be everything in order in that regard.
Yes, sir.
Okay, I just want to make a record of this. I'm going to call my principal witness this evening, Mr. Wolf. Would you step forward, sir?
Okay, before we get started, let me not remind you, let me ask you that in order for the public who's watching this on TV to hear you all, you'll need to speak directly into the microphones that you have there. They quickly lose the sound.
Like the rock singers think, you got to get right up into the microphones. Come in. Okay.
Could you please raise your right hand? Do you swear or affirm the testimony you'll give here before this board is the whole truth?
I do.
Kindly state your name and address for the record.
My name is Bradley Wolf. I live at 20 Metacomet Drive in East Granby, Connecticut.
Okay?
Okay.
Okay, Mr. Wolf, would you
No,
tell the...
Is he presenting expert testimony? Or?
No, I'll tell you who he is right now.
Okay.
Okay? Mr. Wolf, would you tell us what you do for a living, sir?
I'm an attorney practicing in Hartford.
And what is your relationship to this property?
My brother and I are the members of EBW Property LLC, which is the owner of the property.
Would you give the board the benefit of a history of the property? I will note that our submission for the appeal does contain a biography or a chronology of the ownership of the property, but I think to make a record, I'm going to ask Mr. Wolf to go over how long this property has been in the family and how it's been operated since that time.
Sure. Let me go backwards. My brother and I inherited this property from my father in approximately 2009 when he passed away. If you looked at the title, it would be an irrevocable trust. He was 98 at the time, and I was basically managing the property. In turn, my dad inherited the property from his stepmother in the mid-70s. It had been operated as a gas station continuously at that time. She inherited it from her husband, my grandfather, Edgar Wolf. He built the property, or caused the property to be built in August 1930 on this site for the Tidewater Oil Company. So this property had been operated from 1930 until the 1960s by the Tidewater Oil Company, which either in the 60s or 70s merged with Getty Oil, and Getty Oil was the principal tenant who subleased the property, but it has been worked as a gas station since August 19, well, when the work was complete, sometime in 1930 on.
And to the best of your knowledge, it was never closed or used for any other use than a gas station?
It's always been referred to in my family as the Getty property, and as far as I know, it had been continuously operated up until Getty filed Chapter 11. It was actually Getty Petroleum Marketing. They filed for a Chapter 11 in December of 2011. I learned that their tenant had ceased operations about that time.
For the record, since we are taking an appeal, and the appeal deals with the non-abandonment of a non-conforming use, and there's a couple of negatives in there, but we'll get into that a little bit later, what we mean by that. I understand our burden is to, by the preponderance of the evidence, is to show you that it has been a continuous use as a gas station, which was a prior non-conforming use. So I have submitted, but I'd like to mark for the record certain exhibits that I will now have my client identify. My first one, which is the affidavit from 1940, can I mark that as A1? Or do you want the Secretary of the Board to mark it?
Yes.
Yes, please.
Mr. Wolf, I'm going to show you what's been marked as A1 and ask you if you can identify that and tell the board what that is.
Yes, this was one of the family records that in putting together documents to outline the history of the use of the station, that I found particularly helpful because it did establish the dates when he acquired the property and why, because it references the Tidewater Oil Company, who was the original tenant. So that's the history of when this property first came into use, and this affidavit was done to induce Tidewater to do some improvements to the property in 1940.
And who is that signed by?
That's signed by my grandfather, Edgar Bryant Wolf.
And the date of it?
He signed this the 4th day of October, 1940.
Okay. And then I'd like to have marked as A2.
Can I ask a question? I'm sorry.
Sure.
You said Tidewater at that point was the tenant?
This is, up until recently, Tidewater was our tenant. That's who we worked with. Whether they employed people directly or subleased it, it was hard to tell from the records. But we were always dealing with an oil company up until the Chapter 11 of Getty Petroleum Marketing.
So as far as you're concerned, if I'm correct, if I hear you correctly, you're saying that as far as your ownership is concerned, they had a lease with Tidewater through the date that Getty's tenant ceased operating.
Tidewater is successor Getty. That's
From the
correct.
time
Yep.
it began operating in the 30s, you're saying through when it stopped operating in 2011.
11. Continually. There were different leases, some were renewed, some had options that were exercised, but there was a continuous operation. I can only speak from personal knowledge from about 1995, 1996 on, because I became more helpful with my parents' affairs. I can tell you that from that time, from my personal knowledge, up until June of 2012, there was a continuous stream of rent payments.
Can I have this marked as A2? Thank you. Mr. Wolf, I'm going to show you what's been marked as A2, and if you could tell the board what that document is.
Annually, we get a request for a statement of income expenses for income-producing properties from the assessor's office. I chose 1999 because it was sort of in the middle of where we had them, just to demonstrate to you that we continuously represented to the assessor's office that the predominant use of the building was a gasoline service station. These go back for a number of years. I didn't produce them all, but that was the consistent representation to the town.
That's to the town assessor.
Yes, that's to the South Orange Village assessor.
The next document would be A3.
Can I ask a question? The documents we're having marked
All part of this.
are the same documents that were presented to the board, correct?
Absolutely, sir. That's correct. Show you what's been marked as A3 and ask if you can identify that.
This is, A3 is a document that I printed off of the judicial website for bankruptcy court. It's the filing of the Getty Petroleum Market Chapter 11, December 2011.
Now, I'm going to sort of jump a little out of order and ask that we mark this document as A4. This document was not part of the original package, but was submitted about a week later to the board, 2 leases. This is the first of those 2 leases, and I would ask you if you can identify that.
A4 is a copy of the real estate lease between my father's irrevocable trust and Getty Petroleum Marketing in December 2008. This was a renegotiation of the lease on the site.
And could you reference the term of the lease in there?
The term of this, initial term of this lease with rights of options was to January 31st, 2012.
And so would this lease have been in effect at the time that the petition, which was just marked as A3, was filed with the bankruptcy court?
Yes, this was the document that was in force at the time and that we were operating under. It had a option to renew because it began February 2009 and then 2012 it was going to end, but there were 2 options to renew included.
So at the time that the United States Bankruptcy Court took jurisdiction over this property, this lease was in effect?
Yes, that document was in effect. Indeed, they had exercised their option to renew for an additional 3-year term.
Okay. The next document, if we could mark it, please.
Did they exercise their option in writing?
Yes, they did.
And we'll
I
show you-
believe it was by certified letter.
I'm going to show you what's been marked as A5 and ask if you can identify that. That's part of your submission.
A5 is the motion and order regarding the underground tanks. GMPI, when they went from a reorganization to a liquidation, sought an order to abandon the underground storage tanks that had to be approved by the bankruptcy court. So what you have here is the motion, I believe the order, a motion to abandon the tanks, and the 252 Irvington site is mentioned in that order.
You can just reference the chart on the last page so that the board members can
Yeah, the chart
can see
is an 8.5.
where the arrows are pointing to the address. That is this property, is correct?
That's correct, and the arrows actually are abandoned tanks. There are two 8,000-gallon underground tanks on the site presently.
So at the time this motion was filed, or the purpose of this motion was for the bankruptcy court to decide whether those tanks could be abandoned, meaning they were still under the jurisdiction of the bankruptcy court.
That's correct.
Okay. Now I'll ask that this... Too much. And I'll show you what's been marked as A6 and ask if you can identify that.
Does that include this as well?
No, that comes next. I'm sorry. Thank you.
A6 is the order. The order was filed in August of 2012, permitting the abandonment of the tanks and giving the owners of the property the option to not have the tanks physically removed from the ground, but to take possession of them.
And this document will be A7. And I'll show you what's been marked as A7 and ask if you can identify that.
Yes, this is the agreement between myself as a member of EVW Property and the trust transferring the tanks, subject to further approval by the bankruptcy court and others. And this was returned to me in September of 2012. So we've been actively working to button up the site legally, both by having the right to possession of the site and the possession of the tanks.
Okay, so this confirms that Getty was no longer had interest in the site or the tanks, is that correct?
That's correct.
Okay. Now I'm going to ask this.
Was A7 have a title disclosure and transfer agreement?
Yes.
I'm going to show you A8 and ask if you can identify that.
Yes, this is the proposed lease between myself or EBW Property and Mr. Vickroff. We had met in August to see if he was interested in leasing and operating the station. As I just told you, we didn't have all our ducks in a row by way of ownership of the tank. So once we got our ducks in a row, we proceeded with this lease arrangement.
And this lease is dated October 12th, 2012, is that correct?
That's when I think it has a typo in it that says 212, but that was the time period when we had reached our agreement as to terms.
This is a proposed lease.
I think that's what.
Yes.
Okay.
And I'll show you A9 and ask if you can identify that.
A9 is a photograph of the site as it was in August of, well, this one's early.
Okay.
It's a photograph of the site standing along the side looking at Irvington Avenue, you can see that the pumps are there, but the signs are down. I think Mr. Renda had asked that the signs, when Getty wasn't actively selling gas there, that those signs be removed, and they were. Getty took care of that, but that's pretty much the way it was in August of 2012.
And if you were to go to that site right now, I don't know if the lights are on, but if you could see it right now, it's basically in the same condition, is that correct?
Well, those pumps have been removed and the framework has been put in place for new pumps, but that's essentially the same. I mean, it looks like a gas station. It's got service bays. The building hasn't changed at all.
No footprint has been, nothing has been done to the footprint of the
No,
building?
we've done nothing to the footprint.
All right. Let me go back. How did it come that you came to actually have contact with Mr. Vikroff and on behalf of his company?
The site had been advertised for lease. There was a big for lease sign with a Getty number. Mr. Vikroff called Getty, they called me, I called him, and we began negotiating. This happened July, August 2012.
So from July to October, this site was actively marketed for lease for continued use as it was, is that correct?
Yes, and well, actually the advertisement, I understand, had been in the window for a long time. We had active lease negotiations from August until October, when we concluded our negotiations.
I have no further questions of this witness.
Thank you. Okay, do we have,
Well, I do have one further question.
Okay.
I'm sorry. Was it your intention as an owner of this property to ever abandon the use of this property as a gasoline service station?
No, it had been used in that manner. We believe that the tanks were sound. We believe that the location was sound, and that we looked at it as it had been used for that purpose, that it had a good location for that purpose, and we intended to use it for that purpose.
Never let a lawyer say he only has one more question, because now I have another one. The other one being, but for the intervention of the bankruptcy of Getty Petroleum, if they had never filed bankruptcy, would they still be there pumping gas?
I hope so. Like I told you, they had renewed their lease prior to their filing, so as far as we were concerned, they were continuing to operate, market, not use it as a service station and gasoline sales.
Thank you.
thank you.
Can you tell us exactly when it is, what date it ceased operating?
The date when the tenant moved out, or when Getty filed, or when Getty rejected the lease. I don't know the exact date the tenant moved out. My understanding, which is really through Mr. Renda, it was November-ish, October, end of October, beginning in November. I saw some gasoline sales statistics which would indicate that November 2011 was the last sales. So sometime in that time frame, when they actually stopped doing servicing cars, when I was there in 2006 or so, I know they were servicing town vehicles, because you could see the town vehicles on the side. So the date he actually packed up and left, I can't tell you.
I believe the building department informed me that the date, I think it was October 31st. I think it was the last day of the month, but I can verify that with the board if that's the question. But the use permit application was submitted more than a year after that. And the reason it was denied, which I think the board is aware of, is because of Chapter 92-147 of the village ordinance, which deems it abandoned if it's not in operation for more than 12 months. And that was the reason for my rejection of the use permit.
Okay, did everybody hear that? That's important for the public to understand, if these are members of the public. Why don't you repeat that, Mr. Renda?
Okay. When the application was submitted, referring to Village Ordinance, Part 9, Nonconforming Uses, Chapter 92-147, Continuance of Use, subparagraph D. In the event that there is a cessation of operation of any nonconforming use for a period of 12 consecutive calendar months, the same shall be prima facie evidence that an abandonment an abandonment of the use. Any subsequent exercise of such abandoned nonconforming use shall be deemed a violation of the terms of this chapter. So that's the reason that I was forced to deny the application for a use permit.
So if I may paraphrase so everybody understands, the gas station had not been pumping gas for a year, and therefore, according to our ordinance, you had to say that, at least as it says there was prima facie evidence that there was abandonment.
Correct.
Okay. And obviously, the applicant is now before us saying that, no, in fact, it wasn't abandoned. Okay. So that sort of sets the groundwork. It's important that people understand that.
I'm sorry, what was the date of the application, Sal?
Is the application?
December 5th.
December
It was
5th?
received December 5th.
Yeah, is it in the application?
The permit application was received by Ms. Davis on December 5th, 2012.
Not part of it.
So there was an application to this board?
No, use permit application to the zoning office.
Okay.
Yeah.
To pump gas again?
To open up as a new gas station.
Right.
Or a new owner.
And how do we know the date that they stopped doing business as a gas station?
I got that information from the building department. I'll have to go back and check, but I think that's when the building was basically closed, signs were removed. And at some point, I think the pumps were actually taken out.
So I guess we need to know that, right?
I would submit to the board that it doesn't make a difference, and Mr. Renda, who's not testifying as a witness, represents to the board that it was sometime at the end of October. I'm fine with that, because it doesn't make a difference from our position when they stopped, because it all deals with what my client intended to do with the gas station. That's really why we're here this evening, and I will get into that in a moment. So I don't want to put the board through. I certainly don't want to adjourn this for another month just to find out something that may be a difference of a week or two. It really isn't. It's more than a year. If that's the issue, it was more than a year, such that Mr. Renda was compelled to issue the denial based upon Chapter 147, 92-147. So I submit for that. That's fine. That's stipulated.
Mr. Descala.
Questions, right?
Yes.
Yeah, I just have a couple of questions. One, a point of clarification. The terminology used in the lawsuit that released the tanks to the owners, as it were, for use by other lessors, for example. The term used in that document is abandonment. That's not the kind of abandonment we're talking about.
No, that's bankruptcy court language. That's the bankruptcy abandonment of the asset of the bankrupt entity.
So just for clarification, so everybody
That's fine.
understands.
Good point, Counsel. A good point, Mr.
That document is simply intending to release ownership of those tanks for use by others.
Yes.
Not abandonment of those tanks. Do you know when do you have evidence when the zoning law went into effect as it relates to your documents that you were submitting?
No, I don't know when. I don't know when South
Orange.
Orange.
An affidavit that says that the use has been in place since 1930. Aside from that affidavit, you don't have anything that goes back that far. That's documentation that it existed as that use, correct?
Is your question, do we have documentation
Two
of?
things, yeah. So do you have any documents other than the affidavit that goes back to 1930 that shows that that was the use on the site?
I could produce the lease between my...
No, that's not what he's asking. He's asking, when did this become a non-conforming use?
Well, actually, yeah, I was asking two things. So he was answering one of them. which
I was
you-
getting the first one. I do have a lease with Tidewater Oil Company, circa 1930.
Fine.
I could produce that.
Thank you, right. And the other question is when did the zoning law go into effect? Does that predate that zoning law?
I believe it's the RTH zone. Do you remember when that one?
No, I do not know when that was put into effect.
Okay, I would consider that a pretty critical piece of...
The RTH zone is not that long ago. No,
No.
it's definitely within the last 15 or 16 years, I would say.
That zone, yes.
Yeah.
I do not know when the first zoning ordinance was put in place, adopted in the village.
Okay.
Well, someone's offering up
Well,
1960.
That,
So
That doesn't count.
maybe that answer will come up later on during this. And I guess another question is related to the work that was done. The building was replaced. Was there a permit for that?
I don't understand your question, sir.
No,
The
there's some-
1940 work?
Sorry?
The work in 1940?
Yeah, well, I'm not sure the exact date, but there was work done on the property that I would imagine would require a permit under the town code. Do you have a copy of that permit, or does one exist?
The answer is I don't know.
I just, for clarification, what work are you speaking of, sir?
Okay, let me see.
I think he might be,
others ask
he might be
questions while
referring
I
to
pull it
the, this one, that talks about the building being
back.
built.
1999, yeah, it says that the building was built in 1961.
62.
62.
There were
62.
some remodeling done. My grandmother allowed some to be done. I'm not sure we would have had the permit. It would be likely that Getty would have pulled the permit
Well,
to
it
do the
doesn't matter
work.
who pulled it, it's just, do you have a copy of it?
That I don't know.
Okay. That would be evidence in your favor if you had it. That's all I've got for now.
other questions? So yeah, that was the same question I had. When it comes to this interpretation, there becomes the burden of the applicant to demonstrate that this was in use before it became non-conforming. And so, even though this gas station apparently has been there a long time, there needs to be some evidence that the zoning changed after the gas station was already in operation. You have some of that evidence. I see here that there was a lease, this was on the affidavit that you all presented, that there was a lease executed in May 2nd, 1938 to Tidewater. Now, if it was earlier and you have evidence of that, that's fine too, but I see 1938 is the date here. And that your relative or your grandfather took possession in 1930. Anyways, it's back in the 30s where Tidewater Associated Oil had a lease there. And you're saying that there was a continuous lease through that time, and you just presented a annual statement from 1999 just as an example. Is that correct?
Yes, as an example, there are these, I could produce several of those running, for several years in a row of the representations to the assessor's office as to what the use was.
I guess the question is, how far do we want to go in this of demanding each and every year since 1938 to demonstrate continuous non-abandoned use? And for what it's worth, I moved here in 1999. It was in operation. But that's something for the board to consider. So we have 1 year, at least of 1999, that says it was in use.
But we also have the issue of what constitutes abandonment.
Yeah, I think,
Our definition in our ordinance is not the same as what's in Cox's book.
Yeah, I don't know how far we want to go back into this of, we're gonna have to demonstrate that they, obviously it's been in use for a long time, now they're gonna have to go prove historically. In fact, I don't know if that's required or not. Let me go on to my other question, is so make sure the public and I understand. There was a lease in effect, this is A8, no, I'm sorry, A4. The lease that was in effect began February 2009 with the tenant Getty Petroleum, and it would terminate on January 31st, 2012. But in that interval is when the Getty applied for bankruptcy. And even though they're the tenant and they don't own your property, there has to be a bankruptcy proceeding before you can resume operation.
Yes, that's correct, because the bankruptcy court assumes jurisdiction over the lease. It is an asset of the bankrupt, of the debtor, of the company, the entity that's in bankruptcy. And the court then has to decide whether the lease has value, theoretically, meaning that it had the right to occupy that property for additional terms, and they could find a different oil company to come in and operate the property, and that would generate income to the bankrupt estate that could pay the bankruptcy creditors. Or, as the court did decide, we're just going to abandon all these tanks all over, because what we submitted was just as to our 3 tanks, but the list went on with hundreds and hundreds of tanks throughout the country, wherever there was a Getty oil station, because they were all under the jurisdiction of the bankruptcy court. So these things just take time until they get through the court system, the federal bankruptcy court system. And then the bankruptcy court ultimately issued the order that says, we're giving up, we are abandoning those tanks as an asset of the bankrupt's estate. That's really what that's all about.
Well, wasn't the asset actually the ability to operate the gas station, not so much the tanks? Why were the tanks removed from the estate separately?
Maybe I can answer that. My understanding was there were 2 assets. One, Getty Petroleum Marketing actually owned the tanks as an asset of the estate, and they had to go through environmental, and they had to go through the U.S. Attorney's Office in New Jersey, DEP, to handle the abandonment of that asset appropriately because of environmental concerns. The second asset was, as you point out, the lease itself, and that was handled by a rejection of the lease. That rejection didn't happen until the end of June, but that was only half of the story, because I still had no right to use or register the tanks.
So you're saying the bankruptcy court rejected the lease as of June 2012?
12. Right.
Do you have
At
that?
that point in time, they rejected all leases.
Do you have that order?
Yeah, that's it.
No, I don't think it.
I could certainly provide that.
So you're asking for the order, again, can you state that, in June 2000?
There was an order, according to the witness of the bankruptcy court, rejecting the lease as an asset of the bankrupt estate, filed sometime in June of 2012.
And that's not what I'm reading here as far as the motion. That's the motion A5, In re Getty Petroleum, is basically saying we're bankrupt. And this is dated June 15th, 2012.
That's the approximate date of the rejection, so that may very well be the order rejecting all leases.
This is A5, I believe. This is the United States Bankruptcy Court, In re Getty Petroleum, motion of the Official Committee of Unsecured Creditors for an order authorizing and directing debtors to abandon certain underground and above-ground storage tanks. Is that the order?
That's the motion.
No, that's for the tanks, not for the lease. The tanks, in effect, in terms of gas stations, are personal property. They're not real estate. You can open the ground, as major oil companies generally do, they can open the ground, take their tanks, and go home.
Because the owner doesn't want them to be attached to the ground.
That's right. That's exactly right, counsel. So there were two assets, the tanks that they own that they're abandoning and the lease that they're rejecting. The bankruptcy court found there was no value in keeping that lease anymore. We're giving it up. We don't want to have that obligation because as a tenant, they still have an ongoing obligation to pay rent. In fact, Mr. Wolf, if you would return to the microphone for a second. Were you receiving rent from Getty?
Until the June payment, which was received.
June of what year?
June of 2012. So they continued to pay. As a matter of fact, I had indicated to you that there was an acceptance of the right to renew. So I actually got increased rent from February 2009 until June, at which point in time the payment stopped. So June 2012 was the last lease payment.
So within the year prior to the application for the permit, or even just a few months prior to when it was indicated that the operator had stopped selling gasoline, they were paying rent.
Until June of 2012, we received regular rent payments from Getty, or GPM.
Did the ownership take a position in the bankruptcy court with respect to the lease?
Did we? No, well, I assumed one of two things was going to happen. They had a tenant and it was valuable, so they would accept the lease and then transfer it. Or they didn't have a tenant and they would reject. I was rather surprised. I didn't find out about the tenant not being there operating until really August, when I went to the site, or when I was talking with Getty about the time of rejection and saying, where are the keys, why are you going to reject? So there's about a 6-month period of time where there was no operation. I was unaware of it.
But you were still getting the rent?
I was still getting the rent, and Getty was responsive to my questions about paying taxes and paying water bills and things like that.
So how often, from when you began management, in the mid-90s, you said? How often?
Yeah, my father was still alive, so it was really...
How often were you at the site?
I visited, I can tell you I visited the site once in the mid-2006, 2007.
And before that?
I really couldn't tell you.
Any other questions?
Did the ownership at any time ever advertise the property for lease for any use other than a gas station?
No.
Between the October timeframe and the December timeframe, did you visit the site? Did you visit the site? Did you talk to anyone on Village Hall?
I spoke with Mr. Renda a couple of times on the telephone, but I did not come down to Village Hall. I was at the site in August and in late September.
When you spoke to Mr. Renda, did he talk to you about if it stays inactive for 1 year, it's deemed to be abandoned?
Yes.
And did you do anything about that?
I told the tenant to file the application and started this process.
Within the year or at the end of the year?
Well, by the December 5 application, wasn't within the year, because I didn't get the phone call until mid-November, when my proposed tenant called and said, well, the zoning officer came by, and at that point in time I contacted Mr. Renda, who said, we've got to go through a process before this board.
So had no one contacted you, the site would have remained, had there not been a tenant, the site would have been just sitting there.
Well, I was prepared to actively market this site, so I can't tell you that it would have been just sitting there or whether we would have done something different. I can tell you that I already had Mr. Vickroff, and we had an agreement in principle, so as far as I knew, he'd be able to move forward, get whatever permits were required to operate.
But within the year, nothing was actually done.
That's correct, within the year.
Which
but
year are we talking
the
about?
October to October.
Yeah, that's right.
Year. Right, so my sphere of knowledge that the gas station wasn't operating was sometime in June, when I learned that the tenant had left and I wasn't getting rent anymore until I didn't know when they'd stopped. So my sphere really goes from June on. I knew that in June they were not operating.
Yes?
Go ahead. Yeah.
Who found the new tenant?
The sign on the window of the gas station had a Getty sign
Right.
with a Getty phone number. I got a call from Getty saying that Mr. Vickroff had seen the sign and made the phone call. Was I interested? I then contacted him.
And when was that?
That would have been in late July, early August.
And between that time and when you signed with him on October 12th, you were negotiating.
We were negotiating, and I was attempting to obtain ownership of the tanks.
Right, right. And then you signed with him at this point weeks after, sometime, between September 12, when the tanks were released, and October, and middle of October, you signed.
Correct.
I wanted to, Ms. Gruhl, and this is not only for our benefit, but maybe members of the public who are out there, you gave a nice summary of what abandonment actually means, and it may not be what our intuitive sense of abandonment is legally, and I think it's useful for Ms. Gruhl, maybe you can just highlight some of these aspects of what actually is abandonment according to the law.
And certainly if Pat would,
Mr. Dwyer could do it too, but
Sure.
she wrote it down.
They talk about abandonment being kind of a two-part test because it's subjective. It's the intention of the owner, but the only way to really judge that, apart from the owner saying, I never intended to abandon, or what objective factors are there exhibit whether or not he intended to abandon. And that's where we look at all the other things, such as how they marketed it, whether it was leased, how they intended to use it. There are cases which show that non-conforming uses were actually ceased operations for many, 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 many years. And when they started up again, courts have found, well, there was never an intention by that owner to abandon and allowed it to continue even though it had stopped operating for many years. So the bright line test in our statute about 12 months being prima facie evidence, it is only that. It's only evidence. It's not, and as Cox says, the legislature has always backed away from putting down a certain time period and saying if it's after that time period, you've abandoned no matter what. And the cases always say it's up to the intention of the owner. How do you prove that? What happened? What facts are to show what his intention was?
Our code is interestingly worded though, because they don't use the word abandon. They use cessation, right? Which just means stop use, not even abandon. So how does that play into this Cox definition of abandonment?
I think the cases would tell us that stopping of use for any set period of time does not necessarily constitute abandonment.
Okay, so that's what we're grappling here for, and that's what the applicant is saying. They didn't abandon it. Yes, it stopped for a year in some period of time. They're saying they didn't abandon it. There was a bankruptcy proceeding in place with the tenant that kept them from using the property, and so there was no abandonment. It just stopped pumping gas, as it were, and there was no way around that. That's the gist of this. Am I correct? Yes.
Yes, Mr.
and also some of the most obvious would be intent to abandon would have been pulling out the tanks, pulling out everything associated with pumping gas. And that would be the most obvious.
Right, they were actively engaged in not pulling out the tanks.
Yeah, couldn't.
Well,
Couldn't pull the
there
tanks.
obviously was outside influence that, that the testimony indicates.
Actually, the most interesting case, as we learned in law school, when you talk about a case that's on 4 squares, and Mr. Dwyer will know what I'm talking about, is the one that I cite in the submission, which is a case, Campbell versus the Board of Adjustment of South Plainfield, that dates from 1937 of all years, when we're talking about this. But in that case, the gas station had been in operation in 1932, and in 33 it was leased to another party, who then obviously didn't make a go of it, and it got back to the owner, and it just sat idle for years, the court said. And when that came up, the court said, well, they never intended to abandon it. They were doing what they could to get a new tenant. In our case, our hands were tied for a period of time, for months, from December of 11, when the bankruptcy was filed. We couldn't do anything. I mean, if you want to talk about tolling a time limit, and you want to use that argument and say, from the day the bankruptcy court was filed until the day that the assignment back of the tanks and the rejection of the lease, if you want to take that time period out of your 12 months in your ordinance, then we were well within a year. And we weren't in violation of chapter, I keep forgetting the chapter number. 92-147, I'm sorry. So, I mean, that's an argument that we certainly make and that we point out to the board.
We're not, I don't think, at the debate point yet. In these sorts of interpretation cases, does the public have the opportunity to question any testimony given by, like Mr. Wolf?
Yes.
Okay. First of all, do we have any? Are you going to present another witness?
No.
Okay. So then, do we have any questions at this point? Because I was going to open it up for public questions of the testimony that's been given.
May I add one thing? I did have a conscious decision to make with respect to the underground tanks. If I had determined that I didn't want to be in the gas station business at all, then GMPI would remove the tanks at no cost or exposure to me, gone, poof. And I would submit then I had abandoned the use. I made the conscious decision to maintain the tanks, to go through the registration process, to keep them as an asset so that I could continue to market this and lease it as a gas station.
Thank you. All right, so are there
Can
any?
I ask him a question?
Sure.
What is it? Is it a lease provision that would require them to remove the tanks at your request?
That was
or-
the abandonment order, the abandonment of the asset, because they wouldn't let them, it was either transfer the tanks to an owner who was deemed financially responsible, or they're gone because there's potential environmental liability to the state, to the estate. So it was an either or, and a decision that had to be made rather quickly. The decision I made was to maintain the tanks.
You don't have that one, do you?
Well, we have the order on the motion to abandon the tanks, which is A6.
Okay, so we do have that order. Okay. Other questions? Are there any members of the public that wish to ask questions of the testimony that's been provided? Okay, so when you come forward, state your name and address, and then ask questions of the testimony that's been provided. There'll be an opportunity at the end to make statements if you have an opinion one way or the other about this, but this portion is just to ask questions. You want to come forward?
Good evening. My name is Janine Buckner. I live at 157 Fairview Avenue. I'm not sure who to ask this question of, with respect to assets, whether the rules about assets apply to things in general or perishable assets, such as assets like food, or in the case of gasoline, how long a period of time were the tanks emptied? Or did they contain gasoline at the time between 2011 and currently? So my question is, what is the current state of the gas tanks as well as the gasoline? Thank you.
As I understand it, the question is, what happened to the gas? What's the status of the tanks? The tanks were registered with the New Jersey Department of Environmental Protection as having been drained in January of 2012. So they held no product. They still hold no product. Mr. Vickroff had them tested for soundness as part of our lease negotiations. They passed that test, and they've now been registered with the New Jersey Department of Environmental Protection. They won't hold any product until all of the dispensing equipment is in there. So that's the status. There is no gas. There's been no gas since, according to New Jersey DEP filings, January of 2012.
Well, thank you for that answer. Thinking about it, though, is that really relevant to what we're talking about? We're not talking about a question of hazard. We're talking about abandonment. And I'm concerned about, I appreciate your question. I understand where it's coming from, but it's been answered. It's been answered, but I would be concerned that we not stray too far from what the actual issue is here. It's complicated enough. Okay. We have other questions?
James Johnson. I live at 266 Irvington Avenue.
Speak up, James.
I'm sorry. I'm James Johnson. I live at 266 Irvington Avenue. My one concern is if the tanks were drained in January, then you knew you didn't have a tenant. I must have misunderstood. I thought you said you were collecting rent till June and you weren't aware there wasn't a tenant. So it definitely wasn't operating. And it wasn't operating since the middle of October. So that's where now I'm conflicted. If you weren't aware, I know one gentleman asked, you didn't visit, you didn't know. It came across like you thought there was somebody there till June. So if they were drained, then it wasn't operating. And that's where I'm confused to be told that I thought there was a tenant, I was collecting rent till June. I didn't know it was not operating. By that, if the tanks were drained, you would have known that the former tenant left and stopped operating in the middle of October.
I don't believe that was the testimony.
The tanks were drained in January 2012.
That's what we just heard, and he was collecting rent till June of 2012.
Right, but I don't think his testimony was that he thought the station was open until they stopped paying rent. He was just saying that Getty was paying him rent through June 2012, even though the bankruptcy proceeding was going on.
And let's a question. Fair enough.
It just came across that way. I know the gentleman asked you haven't visited, so I think
let Mr. Wolf answer the question. It was a fair enough question. Let him answer the question. I agree with you.
I think that the timing of when I learned things is probably, I learned about the tank closure and responded to that when I went to, there was a filing by a GMPI with the bankruptcy court, and then I went and looked on the New Jersey DEP records, and that's how I found out when the tanks had not been filled. I didn't know that the station was inactive as actually selling gasoline until sometime in the late spring, June time period. So it was the question on the tanks was based upon my research with DEP records, not my knowledge.
I guess we could clarify.
Operating till June. That's what I thought.
I was getting paid rent. I think we conceded and agreed with the panel that the operation stopped sometime November-ish.
I guess we could clarify it to some extent, if you would, Mr. Wolf. You did not arrange for the draining of the gasoline.
I had nothing to do with that. That was all GMPI.
GMPI being Getty.
Getty Petroleum Marketing.
So it wasn't as if you drained the tanks and knew at that point that there was no further operation. You just found out later on that Getty had drained the tanks in January of 2012.
That's correct.
We have other questions? Any other questions from members of the public for the testimony that's been given so far? Okay. All right, so do you have any?
I have a question.
Only to reiterate what I said before.
We've got one more question from our attorney
For the
again.
witness.
Sure.
Mr. Wolf, you testified that you are a co-member of the LLC
Yes.
that owns the property?
Correct.
And what's your percentage share in the LLC?
50%.
And the other owner is?
The other owner is my brother, Bryant, and he lives in Niwot, Colorado.
I know exactly where that
Just by way of closure, I would just point out if...
Did you wish to ask a question? Go ahead, come on. Well, in the long run, believe me, it works better if we let people ask questions.
No, I understand that, but I mean, for the record, at some point we should know...
We'll close it. I saw him, he was leaning forward, he wanted to ask.
That's fine, I have no objection, I'm just
Go
saying...
ahead.
I'm not an attorney, so I didn't quite know how to phrase
your
this.
name and address?
My name is John Passanante. I live at 92 Riggs Place. I'm not an attorney, so I don't know how to phrase this quite in terms of abandonment, but my concern is that you said you have ownership of the tanks under the ground. I'm wondering if he's taken on liability or whatever responsibility for the upkeep of those tanks. I don't know if the tanks are the same tanks that were placed in the ground in 1940, but maybe he can answer that question. And also, I don't think it stands to the good of the community either for there to be a derelict gas station or for there to be an operating gas station with aged tanks being operated by a person who has no experience in the gas business. So either way.
I guess that's a question.
The question was
No, it's okay.
liability.
Exhibit A, I believe it's 5, has the bankruptcy schedule. These tanks were placed in service in October of 1981. They're fiberglass tanks. The reason for lending this to somebody who had demonstrated to me experience in operating gasoline stations was to make sure that they're handled properly, maintained properly, and registered with the New Jersey Department of Environmental Protection, properly insured against pollution.
Those are the tanks that are there now.
That's correct. There are 2 8,000-gallon tanks now. It's the long schedule.
Based on the question that was raised by the member of the public, I would like to call additional witness to help answer that question.
Okay.
Okay, Mr. Vickroff, please.
Please raise your right hand. Do you swear or affirm the testimony you give here this evening is the whole truth?
I do.
Please state your name and address for the record.
Edward Vickrove, 1905 Tanglewood Place, Whippany, New Jersey.
Thank you.
Mr. Vickroff, what is your relationship to, I'm going to forget the name of the company, Gas Group. Group Gas.
I'm the acting president of the LLC.
Okay, and the member of the public just raised the question about, and used the phrase derelict gas station being operated by someone who didn't have any experience. And I'd like to focus your testimony directly to that. You're the proposed tenant, and you were the one who actually applied for the use permit, is that correct?
Correct.
Okay, could you give the board the benefit of your experience in the gasoline service station business?
I'm in the business for 20 years. I manage, build, maintain Anything that has to do with gas stations.
How many are you involved in right now?
20.
And the nearest one to this site, to South Orange, is where?
Valley Street?
Right, in Maplewood.
Maplewood.
Right
correct.
across from Town Hall. If any of the board members are familiar, there's a gas station there. That's one of your stations, isn't it?
Correct, correct.
Okay. So you have 20 years' experience in this business.
That is correct.
That was the only purpose for me to call him as a witness, Mr. Chairman.
That's the Delta gas.
The Delta?
The Delta gas station, correct.
Okay, do we have any questions, Mr. Biggrove? There we go. Okay, yes, come forward, please.
I'm Cynthia Passanante, 92 Riggs Place. The only reason I didn't come up previously is because I actually have a question to address to this person who just spoke, and to the question that was asked. I think we've made it clear that the tanks that are in the ground now are about 30 years old, and not being a professional in the gasoline industry, I have no idea if that is a normal, safe age for a tank to be. So I just didn't know if we might be able to get some information around that.
At this point, Mr. Chairman, I'm going to object for relevancy purposes to the issue that's before the board. I mean, it just doesn't matter if the tanks are properly registered and tested, as was testified to with NJDEP, to get into a question of what's the life expectancy of a double-walled tank and whether it should be or should. That's not before this, with all due respect, that's not before this board. It's not relevant to anything before this board.
I agree. Does anybody else have any objections? I think I just frankly think it's not relevant to this question of abandonment. So if you don't want to answer it, I'm not going to object to that either. And it doesn't look like the board members disagree with me. Okay, we have any other questions?
I do. I was going to ask the witness, Mr. Wolf, do you or your LLC operate any other gas stations anywhere else?
No, we do not. A single-purpose entity.
And personally, you're not involved in any other gas stations either?
No, I'm not.
Okay, any other questions before we deliberate? Ms. Gruhl, do you have any comments or questions?
No, our memo is our memo.
Mr. Adler?
Just so the record's clean, you had said that this was a time for members of the public to ask questions. You want to give them an opportunity?
Yes, yeah. So this is, as Mr. Adler said, this is the opportunity for you all to make statements about this application, pro, con, whatever. So this is your opportunity if you have any statement to make.
Joanna Andreo, 176 Titchener Avenue in South Orange.
Could you please spell your last name?
Andreou.
Andreou.
EOU.
Thank you.
Go ahead.
I was questioning whether or not the new leasee has ever had to abandon or leave any particular properties, gas stations, prior to this application, and whether that has ever been, questioned, because it could happen again.
This doesn't sound like a statement, you're asking a question.
Yes, because I don't want blight there, and I don't want...
Okay, we close, I'm sorry, we're going to have to be a little bit more organized. We gave you the opportunity to ask questions, and now you're asking a question. We're into the statement. If you've got a statement, no more questions.
Okay.
We're taking statements now. Do you have a statement?
Yes, I have a statement.
Okay.
I don't want an all-night gas station there.
You don't want a what?
A gas station open to all hours of the night there. It's a bad corner. It's a very dangerous corner. It's a 4-corner road. When that gas station was put there many, many years ago, there weren't that many cars. And it was a very small little neighborhood with, you know, small stores which are not surviving now. So I'm very worried about the traffic, cars cutting in and out to get into this gas station. And I was wondering, you know, also about the lighting, if it's going to be lit up all night long. And I don't want that.
Thank you. Any other statements?
Hi, I'm Cynthia Passanante, 92 Riggs Place. Having to live across the street from the gas station for, we've been here for 2 years, and for the last year, I guess it's been abandoned. I just would like to say that regardless of what's put there or what decisions made, I'd like to urge the board and everyone involved to try to be as expedient as possible, because more than anything, having that abandoned property, I think, is the greatest detriment to the community. So, thanks.
Thank you.
The reason why the former tenant left was primarily he wasn't selling enough gas, and Getty wasn't happy about that. It's not a really heavily trafficked street as much as Valley Street or, of course, South Orange Avenue. So have you taken that into consideration?
That's a question again.
That's a question.
Okay, it's a statement. So what will happen if this gentleman, he's a businessman, he owns 20, if he's not getting the return on his investment, he'd be smart, he probably would leave. So if it's empty for 6 months or 18 months, would it be if someone said the intent was not to reopen?
That's a hypothetical that
Okay,
we're just
sorry.
not going to,
No, I
that's business.
apologize. I know
No apologies, it's just, that's not,
A lot of people's concern is like, if this is allowed here, that's where we're confused. Like, who tested, are the tanks safe? Getty would send me a letter once a year or twice a year, soil testing, which I was somewhat concerned because, I mean, we've lived there for 93 years. So just a few years ago to start receiving a letter makes you wonder, is the soil contaminated? Why was that little house behind there pumping, testing the soil? It's safety everyone's concerned about. It's a very high traffic corner. It's a traffic nightmare where the tanks are. It's something that is really of a bygone time. We no longer have corner drugstores or a need for the little convenience stores are obsolete, supermarkets are open. So we're just concerned, what will it look like? How will it operate? And will it last? Because it seems like now that if you just prove you were not intending to not open it up again, you could let it go for 3 years or longer. Oh, there was one case cited, and that's what, you know, this ceased operation mid-October. And I understand the gentleman's position, it was part of Getty's lease, so on and so forth, but will this go on forever like this? There was a time where it was not rented even before this long a time for 6 months. Someone took it on, and then he had whatever with the lease, he was gone within 2 years, and then somebody else came in and couldn't make a go of it, and then it was empty for a few months or 6 months, and then Frank was there for some time, and he really made his money on his repairs. That's why he has the shop on Valley. So I know you're stuck if you have to do it by law, but the safety is an issue, and people who live there, I know people on Tichenor didn't like the gas truck driving through that area. I know there are other issues, but that's what will come with this here. And how will it look and be maintained? So that's the concern.
thank you. All right, so at this point, we talk among ourselves. This is an opportunity to ask questions of ourselves, debate the issue. If we want additional information that hasn't been provided, this would be the opportunity to bring that up and make that clear to the applicant if we're not ready to decide yet. And this is also for accountability for us, for both the applicant as well as the members of the public who are townspeople and live next to the gas station. I'll go ahead and start. To me, it's a bit complicated, this question. But in response to some of the members of the public, we're here to do an interpretation of the decision that there was evidence of abandonment. These questions that y'all are bringing up, they're legitimate questions about any business. You know, the viability, that's what capitalism is about. You take a chance, and if you're successful, you make money. If you don't, businesses fail all the time. Most businesses fail. So that's not an issue. Also, the issue of the safety of the tanks is not our issue tonight. There are other regulations that deal with safety of tanks. So we're not considering that. I'm not saying that it's not a meaningful issue, but the purpose of law is that we're here to decide whether this use has been abandoned. And as we've explained, as Ms. Gruhl explained in her letter, and as our attorney, Mr. Dwyer, explained, abandonment is not simply whether you like it or not. It's clear that the case law, it's not just that if it hasn't been pumping gas for a year, it's abandoned. That is out. There has to be more than that. There has to be an intent to abandon. So that's what we're here trying to decide. In deciding whether there's an intent to abandon, my concern is what Mr. DeScala brought up, and it's kind of forces you to go back. There's two issues. This bankruptcy, there was an active lease, and then bankruptcy intervened, and that stopped the pumping of the gas. I think they've demonstrated that that's the reason that there was the work wasn't done there at that site. That doesn't indicate abandonment to me. However, there's this technicality that's absolutely essential to deciding one of these interpretations, is that at the very first thing, it has to be determined that this non-conforming use was established before the ordinance changed. And I don't think the applicant has done that. And I don't have the answer to that. Now, if I had to lay odds that, that this thing was in use way before the ordinance was created, I'd lay odds for it, but that's not our job here. We need it established that this gas station was in effect before the ordinance changed. And they haven't done that.
If you refer to Chapter 92-200.4, which is the supplemental regulations, it identifies the RTH zone, residential townhouse zone, and that's the zone that...
What was the zone prior to that one? I know that one came into existence fairly recently.
Yeah, that came in 94.
Right.
Prior to that, I believe it was... It predates me, but...
When did the zoning code first get written for South Orange?
I can't answer that. I don't think that any of us were around at that time.
But I think they've shown evidence that it was in existence since the 30s, and it's continued to be in existence, so...
Do we demand, do they have to read that proof? So
How would they prove it?
A permit from 1962 would be excellent proof that we at least recognized that was a non-conforming use that was legal at that time.
Or if we
it would have had to have been a pre-existing non-conforming use when the ordinance was created, or if it was created, if the ordinance was created before the gas station and it wasn't a conforming use, they would have had to have gotten a use variance to create the gas station.
The fact that it's there,
that would be another piece of evidence. So
right. But so the fact that it's there means at some point it either predated the ordinance or received a variance or was made non-conforming by a change of the ordinance at some point.
We've faced this problem before in a case of an apartment over a garage.
Right.
And, I think there's a question of how you go back this far, given our own records and given the vagaries of questions like this, to demonstrate that. And I think in this case, similar to the case with the apartment over the garage, where we had evidence going back a similar length of time, I think it was in that case maybe even the 20s, You know, there's a strong case on the face of it that this has been recognized by the town in the form of all kinds of actions we've taken over the years. You know, to be you know, to be recognized that it's there. And I don't know how, I mean, I'm all for dotting that I, right? I just don't know how they would do it.
Well, oftentimes for these types of applications, the best evidence is in the town records.
Right, I was
Yes.
about to ask, is, have we looked at the town records? Is
Well,
anybody?
that information would be in the building, most likely in the building department file, but, you know, then again, I mean, at some point, the town had to give them an approval to build a gas station there, or it wouldn't be there.
Unless it predated approvals, right? But
But
this
then
is-
it-
And then it's a
pre-existing.
then it would have been a pre-existing non-conforming
Right,
use if the
then
ordinance
on the
that was
face of it, it
created,
is
so, I
a
mean, no matter how you look at it, I mean,
pre-existing use.
Susan?
Do we know what the zoning was prior to 1994?
No, and sometimes that's what we've seen in these cases, is the applicant goes to the town records and finds those. This is very thorough in terms of the intent to abandon. It's
It's weak on the other end.
it's what the town records indicate as to either the zoning, and as Sal said, and as Pat said. You know, I would agree with both of their
But we may
comments.
find, I mean, I don't know the answer to this, but we may find that the town adopted their first zoning ordinance in, pick a date, 1950.
Could be.
We may find that it's silent to this particular property, that we have no way of knowing
Yeah.
what was on that property as far as structures. We may know, I mean, we could
have
probably be
evidence
pretty
here.
certain that it was a gas station.
Yeah, there's evidence here from 1930s.
Right, but we don't know whether that, I mean, depending on what the zoning ordinance says, it may be silent to that property. It may not tell us much other than the fact that maybe tacitly it was accepted,
That's right.
you know?
When-
To me,
typically when zoning ordinances are initially adopted, going way back, they
You're gonna have a
don't
lot
consist
of
of much more than a
No,
map.
no.
You know, they got a map with some lines on it saying, you know, residential, single family, that kind of thing, and they don't have much to describe any of these. They got thicker through litigation over the years.
I mean, I think we're dealing with a pretty narrow question, which is really two questions. Is it a legal non-conforming use, and did they abandon the property?
Right.
And I think, as you said, the answer to number two is pretty clear, that no, according to the definition in Cox book, they did not abandon the property.
It's not in the definition of Cox book, it's case law.
It's case law, that's what it is, right. Which is, of course, in conflict with our zoning ordinance, but that's not the first time that that's happened. The question is it a legal non-conforming use? And, you know, to me, the preponderance of evidence says that, yes, it is. I mean, I don't know that we're ever going to have a piece of paper that somehow proves it. It's much like the Zubek case, where you sort of have to parcel things together that are, you know, make sense. And to me, if we have a lease here that talks about, or an agreement here that talks about the oil company in to their own substantial cost and expense is going to rehabilitate and improve the property. To me, that means that we had a gas station here in 1938. I think that's pretty certain that probably predates a zoning ordinance in South Orange.
I agree.
And I think to a big degree, it's just a preponderance of bad events that sort of put this here. You know, if there wasn't a bankruptcy, chances are we wouldn't have this issue.
That's right.
Well, when we know in 1994 it became a different zoning district.
Right.
Would that have meant anything to the gas station? Did they have to, they've been there, do they?
Had they
No.
applied within 12 months for a certificate of non-conformity, they'd have it on record. They wouldn't be here tonight, but
Right.
that didn't happen.
Okay. All right, so that's what could have been done at that time.
And that can still be done at some point, if they wanted to apply to this board for a certificate of pre-existing nonconformity. But I think that gets to the point of more evidence. Right now, they're just looking for they're just trying to show the board that there was not an intent to abandon this property as a gas station.
That part's pretty clear.
Yeah, that's okay.
So-
But do we have records of our prior ordinances? I mean, don't we keep that stuff?
It must. I mean, there's a certain amount of, I don't want to use the word laziness, but it feels like there's a certain amount of relaxedness about whether or not people need to submit information and whether, you know, we can, I mean, ideally, we would have, in this book, a listing of every zoning change that was made, with the date that those changes were made. Most zoning books have that. Maybe it's something that we can request in the future for Board of Trustees.
Well, this does give the date. This does give the date of when the ordinance was adopted, creating the RTH zone.
Right.
But I mean, the ordinance, the earliest date I see is 1981,
It's not a list.
you know?
What would the applicant have to do to definitively establish this question that it was a pre-existing non-conforming use? Do they have records? Is there something here buried somewhere, you know, in the walls that gives the old ordinances? I mean, would we be asking them to do something they can't do, or is it a matter that they should have just done it and they can do it, and it's a matter of spending a couple hours, getting it done, coming back, and proving it? I mean, this is, you know, I'm ambivalent about this because they've established that there was no intent to abandon, but there's this other prong that is uncertain here, and I get a little concerned about letting that stuff slide, particularly if it's easy to establish one way or the other. Sometimes you can establish it, like in the Zubek case, it was just murky.
That's right. That's right. And yet we had a body of evidence that documented continuous use and a body of evidence that showed that the town had sufficient knowledge of the use that had they thought it was inappropriate, they would not have let things go on. I think in this case we have a very similar record that's been established.
If that's convincing to the board members, then...
Well, actually, I'm comfortable, you raised a question about what would it take, and Sal, can you answer that question? What would it take to definitively answer this question?
They would have to go through, digging through the building department files and see if there's any resolutions in there, go through the tax assessor's files and look back at the old tax record, see how it was assessed over the years, look at deeds, look at things like that.
What's the state of those records? I mean, is this paper or is this?
Yes, it's paper.
Or oftentimes it's the village clerk, who is the keeper of the records on all ordinances that have been adopted. And ideally, that would be where it would be, because I'm not sure the tax assessor records necessarily relate to legal they
No, that's right.
acknowledge what it is,
No,
but they don't necessarily acknowledge whether it's legal or not.
Well, what you would be looking for would be resolutions or approvals at some point, you know, for this gas station to be built.
You're, okay. I was thinking as to
I mean,
when the ordinance.
Going back to, you know, the 30s when this was done, there had to be something, or I would assume somebody approved them building a gas station in this location. I mean, it's a little bit different than that other application where that's an apartment in the back of his garage, you know, upstairs. It's a little easier to hide.
Well, that's true too. With the gas station, it's visible.
It's public.
It's public. It's different from referring to Zubek case. This is a case of a homeowner who converted basically I guess
servants' quarters, basically,
yes, a carriage house
over the
into
carriage
an
house,
apartment.
correct.
So that was kind of done without anybody's knowledge. You know, gas station's obviously there. It's not secret. If the town had a problem with it, you know, there's a point there too.
And there's also to Sal's point in 1962.
Yeah, I think the 60s.
The building was built. It was constructed in 1962.
Where does it say that? I missed that.
This is in the document that the applicant submitted from 1999, the annual statement of income and expenses. shows that the building that currently exists, I'm sure there was a building different than that previously, was
A2.
built in 1962, right? And to Sal's point, we probably wouldn't have let them build a new building. It's not like they could have done it covertly. You know, they put up a big screen and voila, there was a new building there, you know.
Well, unless we
So-
thought it was a pre-existing use, non-conforming pre-existing use then.
Right, that would be evidence that would be good enough
And
for
if,
us. I would
and
think.
if the town didn't think, they would have stopped it.
That's
So,
right. That's
Maybe
right.
they were more lax then. I mean, at the end of the day, and I wouldn't want to hold this applicant hostage for this kind of information, given the preponderance of evidence that exists. But at the end of the day, I think that we should hold applicants to submitting the appropriate amount of proof. Very minimal information. When did the zoning code go into effect? You know, when was their
So
use?
you're equivocating.
No, I am. I'm saying that this application, I think, is fine for us to go with what we have. But I want to go on record as saying that we can't, on a
Or a more
regular
for- a
basis,
more
allow
for-
people
so-
to come in without the basic information.
In these cases, you would like us in the future to be asking more explicitly for them to do these searches.
We can do that.
We can always-
Yeah, I perfectly think this is enough, but I'm concerned about saying in the future, this is the case before us. This is the kind of case we're going to get. It's always, it's either going to present it or not. This is our opportunity to say, do it now, or
I'll
this
save
is
my
good
future
enough.
statement for another conversation, then, but it's one worth having. It's just a great opportunity to have it, that's all.
Yeah, but what do we lose by, or what do we gain by making sure it's done? And I want to agree with Rusty. I think that if the information is available, let's go get it. Let's go get it.
I'm gonna go back to the point. I
Well,
started with.
at least, if it's not available, let's know it's not available. But we can't assume and say, well, we're not sure if it's there.
I think we have evidence in front of us that that this use was first of all public, was known by the town, and was reviewed by the town in the 60s. We know the zoning was changed. We know a number of things here that are indications that this was an acknowledged use in the zone, right? This is very different from the apartment case in that regard, because the other one was private. And I'm just asking again, what is it that they could go find that would definitively prove this one way or the other? I don't know what they could find, the date that the zone changed. Well, what does that prove, right? That doesn't.
They could find when was the date that there was evidence that there was a zoning ordinance for that area of town, the first time that they came up with it, and maybe that this gas station predates any zoning ordinance.
That would be very clear evidence, right? So if the zoning code came into effect in 1940, 2 years after their evidence that it existed, then that would be proof, ironclad, no two ways about it.
but it would still be a pre-existing non-conforming use.
No, that would be.
Okay, but let's go, because I think last time we walked through the possibilities. If the zoning came after this date, then it was, assuming, then it was clearly a pre-existing non-conforming.
That's right. That would be the proof we want, right, in general.
I'd also have,
If it came before, and they were allowed to build a gas station in the zone, then what?
Then it was a permitted use at that
It
time.
was a permitted use.
Or they received a variance, in which case the variance lasts.
Right, the
Forever.
variance would rule.
Yeah.
It'd still be attached.
We wanted to see that.
But you have to make sure on these types of applications that at the time the ordinance was changed, making it not permitted in the zone, prior to that, it was a legally permitted use in the zone. And that's the question, and we don't know what.
Let me go through this again. Let's say at the time the zoning was changed, making it a non-conforming use, there's only two possibilities. Either it was previously a non-conforming use in the zone, or it was previously variance and allowed to be
But that's an
permitted in the
assumption.
zone.
Or a predated zoning altogether.
In which case, what is it? If it predates?
If it predates the zoning code, then it's a legal non.
That's right, that's right.
Right.
So there's only, I guess, I think if we build this tree, there's enough evidence on the table to say that this is either a pre-existing non-conforming use or a permitted variance must be issued at some point to permit it.
Well, there is that possibility it was built without any type of approval whatsoever, even though it wasn't supposed to be built there. And then later on, the ordinance was changed, again reaffirming it's not supposed to be there. But at the time it was first built, it wasn't a legal non-conforming. For whatever reason, they simply built it without an approval.
Just say on this 1962 date, I mean, this is not really proof of anything. It's an annual.
It's a proof of that an action happened which the town would have been aware of.
Well, it doesn't even, it doesn't. This is not a building permit. This is just, somebody said 1962. I mean, that doesn't mean anything.
All right, so look, we're hemming and hawing on this. I think the issue is clear. We need to decide then, do we all agree that they demonstrated no intent to abandon?
I agree with that.
We're okay with that?
Yes.
Okay, so then the question is, do we want to adjourn, hold them up for them to demonstrate, convince with more evidence than they have tonight, that they were a prior legally existing prior non-conforming use? Do we want to make them do that, or do they have enough evidence here, as Mr. Parlapiano said, for us to say that they've established that? That's the question.
My opinion is they have.
What do we do? I believe they have, and I guess the other thing I would ask for those of you who might be thinking the other way is just, what happens if they come back and say they couldn't find that letter in a file, which I think is a highly likely case given the state of records and the number of years. What if they can't find that definitive piece of paper, right? Which I think is quite highly likely.
Yeah, I feel also that at this point, since they have satisfied the burden of the most important issue, abandonment, to send them on a search for something that may not even exist, I think raises an additional unfair burden. So I'm satisfied that we have enough evidence here to move ahead.
Well, I think the applicant was advised that there were these issues, that that's what they have to prove, and they haven't even addressed the first issue, which is the legal pre-existing non-conforming use. So, yes, it may be that they can't find it. It may be that the early ordinance doesn't exist, but it may be that it does exist. So, I'm not comfortable saying, well, they didn't address it, they didn't look for the ordinance, they didn't try to give us a date, so what? I don't think it's a so what.
Okay, thank you. Mr. Semper?
I think you know where I am.
No, I don't.
Well, no. I'd like for them to prove exactly what Ms. Adler is talking about.
Mr. Scala?
I guess I share your ambivalence, Mr. Chairman. I mean, it's something that in this particular case, I think there is a significant amount of evidence that suggests that they've been practicing this use in open, flagrant openness, as it were. Even to the point where there was a building that was built and torn down, another building built in '62. That I don't think that it could have gone on without the town's knowledge. And in that regard, they've clearly been here a very long time. I think it's incredibly unlikely that this is an illegal non-conforming use. So I'm inclined to I guess go along with the argument that they, that we should overturn the town engineer's decision on this particular case on the two grounds. One, that it's not an abandoned use, and the other, that there's sufficient evidence to support that this use has been here as a legal non-conforming use for a very long time. With regard to one of the things that was said this evening about whether it's fair to ask somebody to look at town records, I definitely want to go on record saying that I think it's definitely fair. We have a code that says that's something that they're supposed to do, and if they don't do it, I'll say again that I think it's lazy, and it puts us in an unfair position to have to make decisions without that data if it exists. So, but having said that,
In this particular case, you think they've met their burden?
I think they've met the burden.
Okay. So there's your four votes right there. I could give my opinion now, but it's kind of easy. People accuse me of being weak-kneed after the decision's already made. So it doesn't really matter. I will say that I think it's a close call, but I tend to think that they knew what they were supposed to do, and they didn't actually show what they needed to do clearly. But I'm okay with the four members of the board who've decided otherwise. So I think at this point you've got 4 votes. I think we should take a motion.
Before we make a motion, can I make one comment of, this is kind of just literally a comment to the owner and the operator, which is, you heard neighbors tonight speaking about the site, the operation of the site, the issues. And I would just say to you, you're both absentee owners in that sense. You don't live in the community. This is a non-conforming use in the zone. It's a residential zone. You have, residential neighbors. And I would just ask you, as people who are looking, to make money, by operating a business that's non-conforming in that neighborhood, to think a little bit like neighbors, like as if you lived there, and to do what you can to mitigate some of the questions about the operation and of the site to the extent you can. I mean, obviously it's a non-conforming use, but I think those are real concerns, and we hear them often about non-conforming uses. That's why zones are created, right? And there are reasons that you have a right to continue to operate this under the law, but it doesn't change the fact that it's a non-conforming use and that it damages the zone a little bit, right? And so going a little distance to see it from their point of view would be very nice.
On that, I wrote on my envelope here, social impact. And I think we were saying the same thing. And one of the, I know the neighborhood pretty good, and one of the things that happen around there regularly is whenever there is the light is on red and it slows down the cars going across this way, folks come through the gas station. And what happens is there's always a cop around because they actually know that's going to happen. So lots of folks get tickets from coming through the gas station. So I think that, again, let's look at the social impact of making that corner a little better.
Thank you. So maybe we have a motion?
Yeah, I'll move that the application, how do we word this? The application, it's not really an application, right?
The appeal. The appeal.
The
appeal.
The appeal.
The appeal be approved.
Be affirmed.
Be affirmed.
Overturning the zoning officers.
Correct. So overturning the zoning officer's determination of abandonment.
Right. Okay, so there's a motion. May we have a second?
I'll second.
Okay, Mr. Don?
Yes.
Mr. DeScalo?
Yes.
Mr. Parlapiano?
Yes.
Mr. Reeves?
No.
Mr. Semper?
No.
Mr. Aller?
No.
And Mr. Shapiro?
Yes.
So, it's overturned. Congratulations. Thank you.
Thank you for your patience. Thank you to the staff. I got to know Ms. Davis quite well with my almost daily submissions to her.
I would ask that in the future, if you have one of these things in front of this board, that you do the research in the town records for zoning change dates and permits and variances that may have been granted.
This is
Thank you.
Okay, well, this is actually a question for Mr. Don. We might as well address this here on the record, put us under some accountability. This is not the first time that's come up. We've kind of looked around, somebody else should do it. Is this something that the employees in town could do, or is this something our planner could do? Give us a chronology of the zoning ordinances in this town as they've evolved, other than just what, I happen to have in my 2007 code book. Is there any document like that exists?
I don't know that we would have the ability to
Sounds like a job an intern could
do that.
Well, good summer intern.
Good summer intern.
I'm sure there's probably some record of when the first ordinance in town was adopted,
You know, if you get some,
because that would at least give us a starting point.
Newspaper reviews, I mean, an intern could
I
definitely,
think
somebody.
Who has the Village Hall interns? We have Village Hall
Well,
interns?
one thing
No.
that may be helpful, although I'm not sure, is supposedly the ordinances are filed with the county.
Oh, so the county records, maybe.
And the county may or may not.
Depends how they're filed.
Well, I know.
They'd be
I must
indexed,
say,
at the very least, right?
I must say, we have in other municipalities found records of old ordinances where you found bizarre things like no bear baiting is permitted. Just in case you want to know whether it is or isn't.
No.
Bear baiting.
Bear baiting.
Oh, okay. Giant traps that people get their
those
feet
things.
stuck in.
But I guess the first step would be to ask, I would think, the village clerk what she has in terms of her records, whether she has a record of the first ordinance.
That would seem to be at least a starting point.
That's an easy kind of
Okay,
question.
so I'm going to call up Jetta and say, can you talk to the village clerk and get the ordinances? So that's what I'm going to do. Guess what? You just got an assignment. And you can say that this came from me, the chairman. And if she balks at that, I'll come and talk to her. But we'll start with that. Yeah, doesn't mean she can still balk. But then I guess we could write a letter to the county asking for the ordinances of South Orange.
I don't think they're gonna give you them. You have
think
to, you
they're-
have to go and search.
You have to go search them?
Yeah, you have to go.
Okay, all right.
We could have the interns.
Yeah, the intern with the magical
We have an intern.
Deus ex machina there, huh? Jeez, the intern.
We have an intern at this point from the,
Okay,
from the
all right, so
university.
that's one thing, one small thing we can do. Okay, so let's move on to remind ourselves what's up next. We're going to have then the Titchener Avenue will be up. Then I assume we'll have two other cases as well. The 174 Church Street and 5th Street, so those will be 3 cases.
Rusty, I got something on 301 South Orange Avenue. I
Yeah,
haven't heard about.
we've got South Orange Avenue too up
That'll
there.
just be complete.
That'll be for completeness though, right?
Right.
Yeah.
And we have Seton Hall in the pipeline.
And Seton Hall.
And then what's the...
301 South Orange Avenue is where, that's one my go?
301 on the
No,
corner,
yeah,
corner of
Park
Grove.
Place.
Yeah,
Park Place.
is that completeness? I thought that's ready to go.
No, that's completeness. That was just filed.
Can we've never gotten through 3 in a single evening. Should we?
No.
I'm sorry?
We've never gotten through 3 in a single evening, I don't think. Maybe once in 10 years. Number 1 is going to be Titchener Avenue. Number 2, I assume you have these in order. Number 2 will be Church Street. Number 3 is Bianca's LLC. Should we tell Bianca's LLC that, should we put them off to the next month, or is this, we can't?
I think you would have to announce it at the meeting if it's going to be.
We could probably get to it, but we're probably not going to finish it. Well, that's the way it goes. But and then we've got the completeness that we're going to hear first on South Orange Avenue. So we'll do that
Yes.
first. So we're gonna have a busy month.
There'll be 2 completeness.
2 completeness hearings?
Yes.
The one that was in,
Seton Hall, and so we're gonna have 5 things to do, 2 completeness and 3.
I think we're looking at a special meeting.
Hard to believe,
Did that-
since we had a
did the
year of
third one-
no
Right.
activity.
Notice, did they send notice already for next month? When you,
None of these applications are noticed for next month. They'll notice it.
Can
so
between
why do
now
we
and-
have to announce it at an open meeting? I mean, why just call the applicant and tell them, notice it for the following month? Can we do that?
well, there's a timeline in the MLUL and how long you have to take before you hear and complete the
That's why we
application.
do completeness.
So, depending on the type of application, what type of variance relief is requested, you have a certain number of days.
Okay, thank you.
Okay, so we should schedule them.
You should schedule them.
Okay.
If you want, we can notify them if they want to ask for a meeting separately.
Or if they want
If
to,
they want to ask for a separate.
or if they
Special.
want to back off and do it the next month, they could do that too.
Nobody ever wants to back.
Nobody ever wants to back off. Well, I mean, I just can see what's going to happen here. We may not get to them.
No, we won't, but if we do 2 completeness
2
and
completeness
1
and
full
2
case.
full applications. We should probably call them, we're going to schedule them, but if they wish to go to the next month, or can they ask for a special meeting?
They can.
Do we have to oblige them? They can ask for a special meeting or go, I think we should do them that favor, because I think they're gonna be just as upset sitting here, because this is a local, Bianca, this is probably somebody local, they're just gonna be sitting here.
Bianca's is Mr. Cruz, correct? Mr. Cruz.
Yes.
Oh,
it is.
of the,
Prospect Street?
Of the prospects.
so who
Yes.
can call the Mr. Cruz and say, hey, we'll put you on the schedule, but if you want to back off and do it the next month, that's
Another one?
what we would advise.
I'll call him if you want, Mr.
Can you do that?
Sure.
Okay, thank you. Let's do that. Because that also means you're gonna have people from the public sitting around all
That's right.
evening, for no point whatsoever. And I know where this is heading. All right, so let's do that. Let's do that. Any other questions?
Russ, did you send your letter already to the Board of Trustees?
Yes, I did.
So is there a way to communicate this issue with the conflict between the code and the state law on cessation of use for 12 months versus, abandonment of use and what it really means?
That could go
Because-
in our next annual meeting, our next annual letter.
Right, which would be about 12 months.
And if you can keep that in mind and put a post-it on your forehead, I'll be glad to put it in there. I mean, that's what we do.
Why?
Mr. Adler is
Why?
great at that. He never lets anything go. You should remind Mr. Adler.
That's interesting. I mean, what is cessation of use, I understand, but abandonment of use makes it a circuitous question. I mean, if you have to say they've abandoned it for 12 months, how do you determine they've abandoned it?
I don't see a conflict.
No,
I think cessation is
cessation
prima
of
facie
use-
evidence
That
of
it's
abandonment.
that's abandoned.
I
Yeah,
don't see it as an
cessation's
issue
fine.
personally. I think it's just saying, well, it's not been operating for a year, check it out to see if it's been abandoned.
And what it does give the board the opportunity to do just what you did tonight and have them show you that
Gives you the opportunity to turn
they
down the permit.
had no intention of abandoning.
Well, what happens if if a landlord loses the tenant and can't find a new tenant? Does he lose the right to use that premise for that business?
No,
Because
clearly
it takes him more than a year to find a new tenant?
No.
That's basically what we were talking about before.
Each case is
Yeah.
different, and you'd have to use your judgment. They could be trying to pull the wool over your eyes on something, and saying, oh, we're really trying. That's where we use our judgment.
If the place has been up for rent for...
Well, right, the longer it goes, the more evidence you have that they actually have abandoned.
If they show proof that they have been out there and they have been advertising and marketing and everything, they just haven't, there's their proof that they haven't, tried, they had no intention of abandoning the use, they just weren't able to.
I think this board kind of remember that one time that same Getty, he was coming here to upgrade the premise. That owner did not want to pay for it. We got outside that he was coming to do some work, respect to the lights and other things. And
I remember.
and Frank pulled the application.
Oh,
I was just thinking about if you're in a very bad business
You put the
environment,
application because there was no business on that corner.
the landlord is trying everything he can to rent the property, but it's a bad business environment. Meanwhile, the landlord is paying taxes to the village, paying taxes to everybody else. And then to end up losing the right to use that property would be really adding insult to injury.
But I think the case law reflects that. Okay, any other questions? So our next meeting is Tuesday, April 2nd at 7 p.m. Let me review. You've got some resolutions about appointments. You're going to contact a couple of the applicants. I'm going to remember to let Jetta know about contacting the village clerk to see if we have any old ordinance plan somewhere. Okay, that's it then.
You think it's worthwhile for the village or the board to advertise for a summer intern?
Yeah, in general. I mean, for,
We can pay for that.
No, just say it's a voluntary position, 2 days a week or 1 day a week, then give them a job.
it gives them credit when they're
Something on their
applying
resume.
for college somewhere, you know.
There are issues about there, and I use summer interns quite actively in my business. We pay them because there are some issues about them being unpaid these days. But it's a minimal amount of money and we get wonderful work out of them. So this feels like a great intern project.
You want to lend one to the village?
I'd have difficulty doing that.
Is anybody volunteer to supervise this intern? Everybody, yeah, that's what I thought. Yeah, right. Okay. The meeting's adjourned.
On that note.